Made previous lawsuit.
Ah, yes.
My lord, with regard to item number 5, my lord, probably the CD is not available with the landed PP, my lord.
He will confirm the probability.
No, my lord.
No, he will confirm the probability.
Yes, my lord.
Yes. When?
On fifth, my lord.
Learned TK, no, Mr. TK Bhima, Learned Counsel appears for the petitioner. Learned APP has submitted that the CD is awaited. Petitioner is in interim protection. List again on the 5th of May, 2026, allowing the Learned APP to requisition the CD.
Interim will continue, my lord.
The interim continues.
I am deeply obliged.
Ah,
Looking inferior to item 5, my lord. With the consent of the item 3.
item 5,
Sorry,
huh?
Item 3, my lord. Item 3.
Ah,
With the consent of other side, my lord, we need some accommodation.
Lordship, I'm for response number 2, Lordship.
at the consent of the Learned Counsel appearing for the parties, list this matter again after 2 weeks on, list this matter again on, I do hopper episode date that you choose a date.
Yes, 2 weeks, my lord, without fixing any date.
Ah, not done. We are required to fix a date. More so if there is an interim,
And this is
then we'll fix a date.
this.
We'll fix a date so that we can decide whether an interim should be there. Yes. Fix a date. Tell us a date.
Last part of the.
Episode 20th of May. 20 May.
20. Deeply obliged.
Yes.
May I please, your lordship, as regard item 2, my lord, I am
Ah.
appearing on behalf of PK.
What is the hurry in mentioning item number 2? The matter will anyway come up after item number 1. Yes.
For response.
Ah, after item number 1.
Any date, my lord, after 10, my lord.
Explain to him what I have said.
After item number 1.
Oh, obliged.
Obliged.
If it is item number 50, you can mention.
Obliged.
If it is item number 2, why mention? It is anyway coming up at item number 2.
Obliged.
Take a seat, observe the proceedings. It will help you. Yes.
My lord, extremely sorry, my lord. 28th May, senior counsel Mr. IB Fukan will not be available.
So
28th.
28. Okay, 28th of May.
I'll inform you.
Your holiday, 28th May. 27 May holiday. No, बढ़ाई लेছে আপনি. Extended holiday.
28.
28. Yeah. Yes, Mr. Tiwari.
My lord, during this case, my lord, my challenge is against the order.
Lordship, if I may, with my senior friend, my lord. Lordship, here in this case, your lordship, they have obtained an interim order. They're against the order of framing of charge. What I'm on, lordship, that LCR is not available, wherein the statements of the witnesses is not available for this court, my lord. Therefore, my humble prayer is that those statements may be called for along with all the records. Thereafter, for the adjudication of this matter, your lordship can fix a date. They're anyway on interim, your lordship.
Yes.
The proceedings are said, but my lord, only short question. I'll show only 3 lines.
Huh?
Lordship would kindly come to page 34. The
34.
improved order, page 34, my lord.
34. But Mr. Tiwari, when the TCR has been called for, scan copy.
Yes, my lord. Then, my lord,
Whether we can dispose it of remains the issue. But otherwise show us, maybe
my lord, page
we
34.
can hurry up things.
For a moment, my lord. Now, lordship would directly come to para, last above the para, my lord. Further.
There is no such deception by the accused.
No, my lord. Further from the materials on record.
Ah.
Now, because, my lord, it is at the stage of framing of charge, I have done the hearing and thereafter the court has recorded this part.
Ah.
Further from the materials on record, I find that in the instant case, instant FIR, as well as materials laid along with the charge sheet, because I've also taken the charge sheet. There is no such deception by the accused to the informant or any other witnesses, thereby inducing them to deliver any property or destroy any or alter or whole part or valuable security, anything which is signed or sealed or capable of being conveyed to valuable security. Then the court proceeds to frame a charge under 490. And now, what the pertinent question is, I am saying I am Sachin Tendulkar. I mean, persuading. But unless and until I cheat, then only 419, because 415 will come first and thereafter 409 will come, my lord.
No, the second paragraph. No, the second paragraph.
406, 420 already eliminated, my lord, at the stage of framing of charge, my lord. Thereafter, the
No,
court-
the third paragraph,
Yes,
first
my lord.
line.
It appears that section 406 IPC will not be attracted in the present case on the plain reading of the FIR. No offense under 406 made out. As out, no property was entrusted.
So in that paragraph, she has, the learned trial court has said, okay, 406 gun. But 419 is there.
Lordship.
When there is no
Entrustment, because
Deception.
it's a case of ration card.
Lordship, because the allegation is there was a ration card, the petitioner,
And the younger brother says about the elder brother.
Huh?
that
There
is
is a ration card
and he impersonated the holder of the ration card, and thereby he went to the fair price market shop, and then he cheated the government as well as the.
Now, my lord, is he the designated officer under Essential Commodities Act? First part. Second, has he placed the registrars? Had the fair price shop filed an FIR against me? Who has been deceived? The question comes here. My brother, own younger brother.
it should have been received by him. It was received by you.
Sridhar is my lordship.
Yes.
Same house, same corridor, finds younger brother, 45 civil suits pending between the brothers.
How many?
45. Kindly see, I'll just show. Kindly come, lordship.
Lordship, Bidar is
Page 113.
Ah.
Come, lordship.
Hi.
For a moment, page 109, my lord. For a moment, my younger brother, who is the informant in this case.
Visiting the court for professional purposes.
Lordship.
Advocates are paid. Two brothers visiting the court
Yes.
to give money to the advocates. Very interesting.
Page 108, my lord, the informant in the other case, Anil Kumar Sharma. Which is
108.
108. Deposition of Anil Kumar Sharma.
Ah.
He is my brother. Now, my lord, next page, 109, for a moment. Third paragraph. There are around 45 cases pending between me and my brother in the court. And it relates to same property where we
And
reside.
you have filed 44 cases against him.
Since it's a market, my lord. So, my lord, my younger brother was collecting the rent. Myself and my three sisters were not getting the rent. So, I filed for appointment of a receiver to distribute the rent. And all cases were allowed, my lord. So, now he's finding that difficulty, my lord, because he's not getting the money, my lord. At the end of the day, my lord. Because it is distributed between brothers and sisters, my lord. This is what the problem arises.
Heard Mr. Atal Tiwari, learned counsel, appearing for the petitioner. Also heard Mr. P. Bothak, Mr. K. Bushra, learned additional public prosecutor. You are Mr.
And R. Sharma, lordship.
Appearing for the
Respondent number 2. Lordship.
respondent number 2. The trial court, the scanned copy of the trial court records had been requisitioned by an earlier order of this court. Full stop. The same have not been received. Stop. Registry to issue reminder to the learned trial court to send the scanned copy of the records. List again on. We'll have it on the 18th of May.
Lordship,
Interim
18th,
order.
lordship, could it be on the 19th, lordship?
No, it's a hearing the 20th.
20th, lordship.
Let the trial court records
20th,
come.
lordship, 20th.
20th of May 2026.
Interim order
Interim order passed earlier continues.
Highly observed.
Yes.
My PKO children are out of the station, my lord.
Ah.
Maybe I'll have to wait on this matter. For the name.
A prayer has been made on behalf of the learned counsel for the petitioner, with the consent of the learned counsel for the respondents, that the matter may be taken up after
10, my lord, any day.
may be taken up on 15th of May 2026. Stop allowing the request. List this matter again on 15th of May 2026.
Obliged, lordship.
Lordship, for this, we want to take a fresh step. We have already sent a notice dated on 16/5/2025 towards respondent number 2.
You have taken steps?
Yes, Lordship.
Notice issued, okay. You are Miss?
Sorry.
Heard Miss D. Hazarika on behalf of the petitioner. The learned counsel appearing today has submitted that the steps had been taken and office note reflects that the notice was issued on 16/5/2025. Stop. Trial court record twice, you know. There is no report regarding the service of notice on the respondent number 2. Stop. She was the informant.
No, my lord, it's
Example-
appeal against acquittal, my lord.
Appeal against?
Acquittal. He is the accused person.
Would the accused person
Actually,
ever?
my lord, this matter, my lord,
No, would the accused person ever receive a notice once he's acquitted? Huh?
my lord, they can take the steps through jurisdictional.
Who is Mr. U. Roy? U. Roy. Is someone from your chamber, Mr. U. Roy? No. No. U. Roy is there. Okay. So what next steps?
Maybe, my lord, or through the
You take
jurisdictional
fresh
police
steps.
stations.
Since the steps were last initiated on 16/5/2025, the petitioner would take fresh steps for service of notice upon the respondent number 2 by way of speed post within a period of 1 week from today. List again on 1st of June 2026 along with service report.
Authorized.
M6.
The office note dated 9/2/2026 reflects that registered editor bond hoise. It doesn't happen nowadays. It is only speed post. Anyway, the office note dated 9/2/2026 reflects that neither AD card nor any unserved notice in respect of respondent number 2 has been received. None appears for the petitioner today. Full stop. List again on 18th of May with updated report on service of notice upon the respondent. Number 2. What is the IA for? I disposed of?
Yes, no, my lord. I is pending.
I is for what?
Bail, my lord. My lord, the conviction is 5 years, my lord.
My lord,
Ah.
POCSO matter. So, my lord,
A. Pukon is appearing in the matter.
yes, my lord, as I might
For
have.
respondent number 2.
Yes, Mr.
My
Pukon.
lord,
7. Item number 7.
Your assistance was requested by this court. 5 years punishment. POCSO. Spring for a suspension during the pendency of the appeal. What is your ground of appeal, sir?
my lord, ground is, my lord, at this stage, my lord, I am not on merit, my lord. So, my lord, already 5 years conviction, already 1.5 years, my lord, in jail, my lord.
I don't know.
My lord, at this stage, he may be allowed to go on bail and, my lord, the next.
Lordship, the victim is 7 years old,
And section, so far the section is concerned,
years.
my lord, 10, POCSO 10 of
Ah,
at the time of incidence, this thing was 7 years old, my lord. It was 7 years old, and my lord, both the PW3 and PW2, if your lordship sees the deposition, there is corroboration, my lord. Page page 23, my lord. deposition by PW1. That's was the victim, my lord.
This birth certificate was not exhibited.
No, my lord.
Birth certificate not exhibited.
No, my lord.
But my lord, is there one?
Was it proved in the manner required in law by calling for the register, calling
my
for
lord.
the
Birth
person who
certificate-
issued it, calling for some official? No.
No, my lord.
No, this we are asking not because to find out whether she is a minor or not, whether she was below 12 or not. That is one of the issues. Hmm?
Exhibited. No.
And another thing. Then, how much time have you spent in
My lord,
custody?
in custody, my lord, almost more
Earlier?
than 16 months, my lord.
Earlier, during,
Earlier, 8 months, 3 days.
uh,
And
then you were granted bail.
no, my lord. Earlier, my lord, 8 months, 3 days. Thereafter, he got bail.
Then he participated in the trial.
Trial. And my lord, the judgment was pronounced on 26/6/2025.
From
And
then he
since,
is
since the date of judgment, he is inside. And altogether, my lord, almost 17 months in jail. But
how many times?
my lord,
Here has come.
yes.
That we have seen. 6 to that we have seen. Below 12, okay, fine. And what was your stand in the 313 statement?
My
I understand that 1.5 years.
yes, my lord.
You were behind bars, but we were just trying to find out if you have got a good case for argument.
Yes.
We'll fix it for argument as early as possible.
My lord.
Have the matter disposed of.
My lord.
The moment we go for a bail, then the matter will keep pending for another few years. Since the man is on bail, that is the attitude. So we'll try to take up the matter
My lord.
on a hearing day.
Fix a date, my lord,
Ah.
for final hearing.
Should we keep it on the 28th
28th of
May?
this month.
Yes, my lord.
28th of May, not this month, next month.
Next month.
This is April, we don't have any more 28.
Till
My lord.
This is April last day, we don't have any more 28.
28, my lord.
28th of May.
little bit earlier, my lord.
You have to look at the burden also.
15 to 20.
15 to 20, okay, 21st of May
My lord.
for hearing.
My lord.
My lord.
Trial court records have been received. And again, heard Mr. Swenson and a counsel appearing for the appellant.
June, na?
Mr. Fukan appears for the Mr. Fukan and Leonard Magas appears to represent the interests of the victim. Mr. Bosho, Leonard APP stuff. At the consent of the parties, list this matter again on the 21st of May
Fine.
in the hearing column.
Deeply obliged.
Obliged.
Yes, sir.
Please, Your Lordship, we have filed an IA, Lordship.
For
Substitute petition. There is no respondent, Your Lordship. There is no respondent. Your Lordship, initially, the fact of the case is that a case was registered, Your Lordship, under section 181, 138 of the NI Act.
main file to deduction. Main file to assign. KTR এখন
2014, Your Lordship.
You really want to keep pursuing this
Your
matter?
Lordship, there was a dishonor of the check of 1,50,000, Your Lordship.
Ah,
Initially, 1,30,000 was paid, and remaining even 20,000 is paid, Your Lordship. And I have the agreement, Your Lordship.
then what happened? So why the revision?
No, Your Lordship, to set aside the judgment and order passed by the non-SDGM and Session Court.
So the you are for the accused,
Yes, Your Lordship.
and the complainant has expired.
Yes, Your Lordship.
So now you fear that the legal heirs of the complainant may come and have the judgment enforced after 2014 now
Lordship,
for 20,000 rupees. What was the total amount given?
1,50,000, Your Lordship.
1,50,000 you were required to pay.
Initially, 1,30,000 was paid, Your Lordship.
What was, as per the judgment,
1,50,000.
what was your total liability?
1,50,000.
And you have paid the entire amount of 1,50,000.
80,000 was remaining. Even we have paid that, Your Lordship.
You are saying that the entire judgment has been now satisfied. Where is the judgment?
Annexure A, Your Lordship, page 10.
No. No, sir. You were required to undergo a simple imprisonment of a term of 1 year.
Yes,
And you were required to pay a fine of rupees 1,50,000
yes,
total.
yes.
And in default, to go for imprisonment of 3 more days. Now the complainant has died. Should we keep this alive? We will take on record. Whom did you pay the money to? That agreement? What? Whose agreement is it?
His son, Your Lordship. I have the agreement.
You have paid the 30,000 to the son.
Son.
So you want that 1 year imprisonment to be set aside?
Yes, sir. So
Huh?
the entire, Your Lordship.
No, you have already paid it.
Yes, Your Lordship.
So what? Why set off the entire part? Total amount to be paid. You are not clear on the facts. You could have a disposal today. Yes.
The entire amount is 1,50,000, Your Lordship.
And that entire 1,50,000 has been paid.
Yes, Your Lordship.
The son has acknowledged it.
Yes, Your Lordship.
Complainant has died. You are requesting that this 1 year imprisonment should be set aside.
Yes.
Yes. 2011 he was sentenced to 1 year imprisonment.
My lord.
He has paid up the entire amount by till now because he went up in a revision. Matter went back to the trial court.
My lord.
Trial court reimposed the same sentence.
My lord.
Then he came up in this case. Then he got a stay.
My lord.
Now, because he was supposed to pay 1,50,000 sometime in the year 2011, do you think that imprisonment of 1 year should be continued on him? That should hang on his head for life?
My lord.
In the facts and circumstances, can we do it? In a criminal revision, tell us.
My lord, in a criminal revision.
In an appeal, we have set aside that imprisonment part.
Yes, my lord. But it's a revision, my lord.
In a revision, tell us. In the facts and circumstances, to what extent do we have the power?
In a revision, my lord, to see, my lord, whether, my lord, that is any, my lord, that is the legal infirmity in the part of the appeal, my lord.
But in a revision also, we will also have to look into the justice part of it.
Yes, my lord. For that reason, my lord, that is the long delay, my lord. That is the conflict. That part is, my lord.
Although we do not interfere with the conviction and the sentence.
Yes.
Carrying out the sentence can be set aside. Or
Yes, my lord. It's a long time, my lord.
Go on. Why imprison him for 1 year now?
1 year now, my lord. Already such, my lord, a long gap, my lord.
Give us the law. When? Tell us a date. We'll give it. We'll finish it. Follow. Forget your eye.
Can it be on 6th of May or
But you will give me one judgment
Yes, sure.
that in a criminal revision petition, I can say I am not interfering with the judgment in any manner, but due to the long lapse of time between the original judgment and today, requiring you to undergo the sentence, to undergo that imprisonment at this time may not be fair. Therefore, you would not be required to undergo the sentence.
That is sentence part.
Initially, Your Lordship, when the petitioner went to the house of this respondent, Your Lordship, the son of this respondent, Your Lordship, he did not wanted to take the money. Like it was given forcefully, Your Lordship.
We understand all the things.
No,
You
that
are in a
matter
revision. Is it not? Give us a judgment saying that yes, the sentence can be interfered with. Matter ends. List on the 6th of May. 6th of May. What DB আছে? Huh? As a part hard matter. Hello?
Much of it.
As a part hard matter. Bring me that one case law. Go home a happy man. Udu? Huh? Timber paper. Akono kono.
Item 9.
9.
May please, Lordship.
Hmm.
Lordship, in this case, it is a 1-year imprisonment was used. Petitioner conviction was given for 1 year and fine of rupees 3,000. In default, 2 months after imprisonment. Here, my lord, the victim is the mother-in-law of the accused petitioner.
Victim, what was the offense?
Offense 324, the IPC.
Acha.
That injury. Some injury was caused.
So the mother-in-law. To the mother-in-law.
To the mother-in-law. Now the mother-in-law, after the respondent number 2, informant was the father-in-law of the petitioner.
Is he alive?
After now petitioner respondent number 2 died. So victim, I have filed IA to implicate victim. Now victim is with the petitioner. Being an old man, my lord, and they have compromised person.
So that compromise has to be told by the victim by way of an affidavit or something?
Affidavit.
No, by way of an affidavit or by way of a counsel also.
Counsel also.
Where is the counsel?
Counsel, no notice has not been issued, I think. Yeah. I have filed IA to
that I could have been filed by the victim herself. Matter would have ended.
But the accused also filed.
Is it not? Filed the IA by the victim, matter ends. I don't have to issue notice, nothing doing, finish the matter.
Petitioner also can. Ultimately,
file IA to
ultimately the victim will appear and
that takes time.
That,
but then time is
she also that also can be done.
Or what do you say? No,
they filed this IA, my lord, to implement the party, my lord.
Along with the affidavit. So we'll allow the implement.
My lord, they said, my lord,
because she's the victim, we allow the implement.
Yes, my lord.
Let the matter be listed on some other day.
Yes, my lord. Because my lord, her presence is.
We'll issue notice. We'll issue. On the implement.
On the implement.
No, not on the implement. We'll implement her.
My lord.
Because the original informant is gone.
My lord.
Victim he wants to implement.
My lord.
We'll allow the implement.
My lord.
We'll pass an order in the revision saying that since we've allowed the implement, he registry to make the necessary corrections, he will take steps for service of notice.
Yes.
On the next date, if the respondent appears,
my lord,
close the matter.
Yes.
This is not an offense as such
my
against
lord,
the state.
my lord, my lord.
It is between son-in-law, mother-in-law.
Yes, my lord.
Let us close it as soon as possible.
Yes, my lord. The 2016 matter.
And that is what.
My lord.
Heard Mr. M.R. Khandakal and a counsel appearing for the petitioner. Also heard Mr. Bushel and APP appearing in the matter. Full stop. The Learned Counsel for the petitioner has submitted that the original informant in What is the case number, sir?
Case number
Mankachar PS case number 258 of 2009, which was later on converted to GR case number 449 of 2009, has expired after filing of the criminal revision petition. The learned counsel for the petitioner has submitted that the prayers in the criminal revision petition are for setting aside the order dated 8/9/2015, passed in GR case number 449 of 2009 by the learned judicial magistrate first class Dhubri, whereby the petitioner had been convicted under section 326 IPC and sentenced to undergo simple imprisonment of 1 year under section 324 of the IPC and fine of rupees 3,000. Oh, first part also you read 326, 324, not 326, 3,000, and in default to undergo further simple imprisonment of 2 years full stop. The learned counsel for the petitioner has submitted that since the original informant has expired, for a proper adjudication of the matter, he has prayed for impleading the alleged victim, since the victim and the petitioner herein are also related through marriage, that the victim being the mother-in-law of the present petitioner, full stop. The learned APP has submitted that the impediment of the victim would indeed render assistance in adjudication of the matter. Accordingly, the IA is allowed. The opposite, Miss, how do you say Musammat?
not Miss Khamijan Bibi.
Accordingly, Khamijan Bibi, wife of late Eli Box SK. You'll find it at page 3. I have marked it, the serial number 3 person, is implemented as a respondent number 3. As respondent number 3 in criminal revision petition number 123 of 2016. IA accordingly disposed of. Then you write in the criminal revision petition. Today, by an order passed in IA criminal number 81 of 2026, Miss so-and-so, don't write Miss, you write so-and-so has been directed to be implemented as a party in this criminal revision petition. The learned petitioner shall provide amended cause title to the registry on the amended cause title being provided. The petitioner shall also take steps for service of notice upon the newly implemented respondent number 3 by way of speed post to be routed through the registry of this court, full stop. List again on 25th of May 18th of May 2026. 18th of May 2026 with the service report on the respondent number 3. Service report of notice on the respondent number 3.
And
Item 10.
If this connected criminal petition has been filed, challenging the FIR filed against me. Subsequently, on instruction by the public prosecutor, we have come to learn that charge sheet has been filed, and the trial court has issued notice. So, by this interlocutory application, we have challenged the charge sheet and that order of cognizance. Well, may I take your lordship to the FIR filed by the.
Tell me one thing. I'm just inquisitive. You have challenged the FIR.
Yes, ma'am.
Now a charge sheet has come out.
Yes.
And you have been issued summons.
Yes.
If we allow this petition, you will be allowed to challenge the charge sheet and the order of summon also.
Yes, my lord.
Are you basing your case only on the setting aside of the FIR, where the consequential relief would be setting aside of the charge sheet and
My
the
lord.
summon?
My-
Or would you also like to challenge the charge sheet, not the charge sheet, the summons, the order taking cognizance,
Yes, my lord.
independent of whether the FIR was correct or not? If you want to do that,
Then I'll have to
then if we allow this petition,
My lord.
your independent challenge to the
My lord,
taking of cognizance and the charge sheet would go. You would have no grounds because there are no grounds in the criminal division petition to do that.
my lord.
But if you make an independent challenge and have the matter taken together, first we can test the FIR.
My
If it is correct, we can test the charge sheet. If it is correct, we can test the cognizance order.
My lord.
But if you take it up at one go, once we say the FIR is okay, you will have no ground to challenge the cognizance orders.
My lord,
What do you want to do?
FIR doesn't reveal as such nothing against
Where is the FIR?
FIR is at my lord page number 18 annexure 1. Initially, CD was called for since the charge sheet has been filed. So,
No, we understand that.
yes, my lord. Page number 18 annexure 1.
Which number?
It is in the criminal revision petition, my lord, main petition. Page number 18 annexure 1.
Oh, no, it must be there here also, no?
In the main petition, my lord, it's not in I.
অভিযোগ মানে শনিবারে যি অসমীয়া পাঠ দিছে আখৰ পেজ নম্বৰ 18
Yes, my lord.
180 দিয়ক দিয়ক মই উলিয়াই লৈছো ঠিক
Nothing against me, my lord. No cognizable.
The accused number 4 is Orup Pathak. You are not Orup Pathak.
I am Orup Pathak.
Huh?
Accused number 4, I am Orup Pathak. Only allegation, my lord. I am the nephew of the informant, my lord.
There is some allegation against you.
No cognizable of it, my lord. Kindly see, my lord.
Have you seen the allegation against him?
My allegation against him, the allegation against me is that I have gone there and stayed for a while.
A few lines below.
That is not offense. I am the
Yes.
nephew of the informant.
It is moral turpitude,
My lord,
not
kindly see, my lord.
And
The offense has been, my lord, incident took place on 10/10/2025, and FIR has been filed on 2/11/25, my lord, almost a month back. Immediately after filing of the FIR, they have come to the family court taking my lord for divorce, decree of divorce against the wife. This is the intention of the my lord informant to for filing this affair.
ৰাতি প্ৰায় 10:30 বজাত 2 নম্বৰ পদকীয়াই সীমা দাস 4 নম্বৰ পদকীয়া অৰূপিত পাঠকক ফোন কৰি মাতি আনি গুচৰীয়াৰ ঘৰত ৰাখে সেই সময়ত 2 নম্বৰ 3 নম্বৰ পদকীয়াত আছিল সেই সময়ত you are 2 নম্বৰ পদকীয়া
I am accused number 4 and 2 is wife and
4 নম্বৰ okay
yeah.
2 নম্বৰ 3
And
নম্বৰ
remaining
পদকীয়া নাছিল
and 1 is mother of the
ঘটনা গম পাই গোচৰ চুবুৰীয়া তেওঁৰ ল'ৰা বিশ্বজিৎ কোনযোগে পিছদিনা গুচৰীয়ানী আৰু ল'ৰা দাসে ঘৰলৈ আহি 2 নম্বৰ পদকীয়া যোৱা ৰাতি 4 নম্বৰ পদকীয়াক কিয় ঘৰলৈ মাতি আনিছিল বুলি সোধাত 1, 2 আৰু 3 নম্বৰ পদকীয়াই তেওঁৰ ল'ৰাক অশ্লীল গালি মাৰধৰ কৰে লগতে মাৰিম কাটিম বুলি ভাবুকি দিয়ে মতে জনোৱাত হাজো থানাৰ ইমানমান তদন্ত কৰা হয় সংগ্ৰহ কৰি পুঁজিৰ লগত গাঁঠি দিয়া হয় Were you also arrested?
My lord?
Were you also arrested?
No, my lord. After receiving someone we appeared before the.
No, putpush kori greptar kora hoy. Kak greptar kora hoy?
Because since the all the accused.
No.
Yes.
Where 1, 2, or where was the petitioner herein arrested during the investigation period?
Yes.
He was arrested.
Yes.
He was granted
Because,
bail.
since the yes,
We are
yes,
not on
yes,
that.
yes, yes,
Was he granted bail?
yes, yes.
There is a bail order.
Yes.
Is the bail order here somewhere? Do you have
It
a
should
copy
be-
of the bail order?
No, it should be in the.
If the bail order says that there is nothing in the CD against you, this is not a plus point. We could have done it today. Give us the material. Aru, I know. Your name is Orup.
Orup
Orup
Pata.
Pata Pita Iman. Bagarbari Thana Iman Gauhati, Ghotana Logo Doito Thakar, যথেষ্ট Iman. Nothing against him as such in the charge sheet also. He had gone there, the rest of the family had beaten up these two people.
Yes, on the next date, my lord. I was not there.
He would naturally not be there. The entire village would be there. Why should he be there? Huh? So what is this IA for?
IA is for my lord.
Yes. IA is for that. Now, do you want to continue with this IA? If you want to, we can allow it.
My lord, then in that case, my lord, I'll my lord, pray for staying the operation of the FIR against me only. Remaining accused, I do not press, my lord.
Then it will be an entire stay. Because if you are an accused,
You have to say, na?
unless and until you appear and participate,
My lord.
the court cannot proceed.
No, you tell.
They will proceed for 3 persons. Then we dismiss this case. Will it start from zero again for you?
I have challenged the my lord.
No, tell us the practical part of it.
Yes, that is true.
Huh? So,
My lord, till the next date, I may be protected. But since
no, I can say that your participation in the trial in the meantime will not be to your prejudice. That much I can say. So that things keep going on against at least the other 3.
My lord.
Yeah. Will that do? Without his participation in the trial will be subject to outcome of the petition, criminal petition.
Yes, that will.
Is it not? Nothing will be. There will be nothing adverse.
Nothing adverse.
And because he's participating.
Otherwise, it becomes infractuous and another petition has to be filed.
This FIR thing becomes
challenging on the FIR. The entire criminal proceeding.
No, he is challenging the FIR in so far as it relates to him.
Yes, ma'am.
So then FIR is only an information. Quashing of the FIR as such would not arise in this case, unless it is a case where no offense at all is made out. Now, if the FIR was to be quashed, he would not be subjected to investigation. He would not have gone for he would not have been taken into custody and all that part. That part is gone now. Dead and gone. Unless he challenges the
proceeding.
I'd like to challenge
the summon.
Yes, because
the cognizance. That yes, you should also be an accused. Unless he challenges that, what can we give?
My lord, I'll challenge. I'll also and challenge, my lord. But that observation has to be made as it has fallen out from my partnership.
Yes, what do you say?
Yes, madam.
Lordship, I pray for adjournment today as my senior at the engaged counsel. She is out of station because of some medical issues here.
I understand, but
Yes.
see, some man is going to face a criminal proceeding. We are not staying anything.
Yes, ma'am.
Was notice issued in this case? No. We'll issue a notice so that you can put in a proper appearance.
My lord, we have already served the copies.
True, we'll record that issue notice part has to be there. Without issue notice, we cannot do that. So we'll issue notice. We'll say PP is there. We'll say counsels for the opposite parties are there. So no formal steps are required. Extra copies to be given and awaiting their response. Your participation in the trial will not be held to your prejudice. Heard, Mr. Swenson on a counsel appearing for the petitioner. Your name, madam?
Miss K. Das.
Appearing, heard Mr. Swenson on a counsel appearing for the petitioner. Also heard Mr. Bush, learned APP. Full stop. The learned counsel for the petitioner has submitted that this interlocutory application has been preferred, praying for quashing of charge sheet number 401 of 2025 dated 23/11/2025 in connection with Hajo PS case number 463 of 2025, as well as the order dated 25/3/2026 passed by the learned judicial magistrate first class Hajo Kamrup, insofar as it relates to the present petitioner.
In PRC case number 1212. Corresponding case, madam.
Corresponding to PRC case number 1212 of 202.
212/2026. 212/26, madam.
It is not 1212, it is only 212, huh? PRC case number 212 of 2026.
Madam.
Since a challenge to the FIR which had initiated the entire proceedings is already challenged in the connected criminal petition number 1622 of 2025. Full stop. Issue notice. Miss so-and-so appears for the respondent number 2. Respondent number 1, comma, who for the opposite party number 1, comma, who also appears for the respondents in the connected criminal petition. Full stop. Mr. Bosho already represents the state of Assam, that is the respondent number 2. Since the opposite parties are represented, no formal steps are called for. Extra copies as may be required to be served upon the counsel for the opposite parties. List again on
22nd May, Your Honor.
22nd May 2026.
Lordship, after 22nd May, she's on leave till 22nd May.
On the 29th of May 2026.
Madam, can it 21 is okay.
Allowing the opposite parties
Madam,
to.
can it be on 28?
28 is a hearing day. Oh no, 28. Okay, 28 is a hearing day.
26 May.
29 is okay.
29th will be fine. 29th of May 2026, allowing the opposite parties to respond to the present IA. The learned counsel.
29th May, we have a very serious civil matter in the lower court. 20.
Two objections, madam. Two objections from the court. Number 1, something pending in another court cannot be a ground. Number 2, there is no lower court. Where is the lower court?
Civil judge.
How is it a lower court?
Sorry, Lordship.
What is it?
Subordinate court, yes.
It's a trial court.
Trial court.
It is not subordinate to us insofar as law is concerned. It may be subordinate so far as administration is concerned.
Right.
So it is a trial court where you first start your trial. Yes. Then we'll have it on the 29th. You are not comfortable with. We'll have it on the 3rd of June. Comfortable for all? 4th of June 2026, allowing the opposite parties to respond to this present petition. Stop. The learned counsel for the petitioner has submitted that since there is no stay operating in the connected criminal petition also, comma, the petitioner may be prejudiced if he is forced to participate in the trial proceedings at this stage. Stop. We have gone through the contents of the FIR and the charge sheet, which have been placed on record before us. Stop. In view of these circumstances, this court is of the opinion that the participation of the petitioner in the criminal trial during pendency of this petition shall not act to his prejudice, and the criminal and the orders passed in this criminal petition and or the interlocutory applications at a later date would govern his participation, his further participation in the trial proceedings.
TCR was also called forward. That is also
the registry to issue a reminder to the learned trial court to send a scanned copy of the TCR.
CD.
Huh?
CD.
Scanned copy of the TCR along with the CD portion for perusal of this court.
Malad has my participant has.
Your we have said that your participation will not prejudice you Your participation in the trial as of now will not prejudice you in any manner, and it will be governed by the further orders to be passed in the criminal petition.
But
You'll have to go and
I'll have
appear.
to pay again, is the trial. my lord.
Yeah, as of now, you have to go. You give the trial court this order. I cannot stay, I will not stay the entire trial. The moment you stop participating,
My lord.
what is the first date that you would do? The first thing you would do is go and appear.
My lord.
They'll fix a date for copy.
That is true, my lord.
Is it not? Thereafter, they'll give you the copy. Now, till that point of time, if you have this scanned copy of the trial court record in your criminal petition is allowed, you are free to go thereafter. But if we stay for you now, 1, 2, 3, even if they keep appearing in the matter will not proceed. They will have a simple, they cannot be given copies also. If you do
In
not
that case,
appear,
I would like to withdraw this, my lord, this IA, and I'll file fresh petition challenging the, my lord, order of cognizance and
whatever you do, unless you appear in the trial court, had it been you alone, we would have stayed it right away. If there was only one person accused,
yes, yes.
we would have stayed it right away. No use in pursuing the matter.
No allegation against me. No
We
cognitive
understand,
offense has been made of.
unless we have a copy of the trial court records,
My lord.
which you are fixing on the 4th.
Well,
Trial court records, once we see, and we find that there is nothing against you,
well, then
set the whole thing aside against
pay
you.
for a shorter date.
I was offering you. I was offering you.
Then I'll pay for a shorter date. my lord.
I know, I was offering you. You had a 27, 28.
No, I don't
difficulty.
have early date, but
22nd May.
main about
Be sort of
I would
22nd May. She's not available.
it.
Since Bihu, she's not here.
She has gone for some treatment, so we have to give her that leverage.
Okay, my lord, then my lord, in May, any date, my lord.
May after 22nd of right?
Any date, my lord.
After 22nd.
Yes, sir.
That is what I had said. 25th,
26,
26th,
20, yeah, it's okay.
25th,
26, my lord.
26th, 26th.
Okay.
26 will do.
We have not given that much time to the case as much time we have given in fixing a date.
Okay. My lord,
Yes.
earlier 2 occasions TCR was called for, but it has not come yet. So
On the
my-
next date, if it is before us, remind us. And you also tell us what is the allegation against him. Can you tell us?
Yes, Your Honor.
What?
The wife of the daughter-in-law of the respondent was having an illicit love affair with the with the petitioner. So on that very night, he was caught. At the night he was being caught, and that day, when the husband reached early in the morning,
We understand these circumstances. We have read the FIR. What crime you say he has committed? Tell us that. That this is the offense.
Your Honor, he's hurt them, like beat them.
Your FIR doesn't say so. Your FIR says 1, 2, and 3, beat us up. That is the whole difficulty. Had you said 1, 2, 3, and 4, nothing here. 1, 2, and 3 beat us up when we asked our daughter-in-law, why did he come?
He was also there at the
No,
The FIR doesn't say so.
that is not the case.
And therefore, the CD was called for.
This is not the case.
To see whether if any of the witnesses have said he had also used his hands and fists. If he has not used his hands and fists on the next day, we will close it insofar as he is concerned. Proceed with the other 3.
Okay.
And this will be a case where the entire elephant will escape with the tail remaining. 3 people beat them up, they will be in trouble. The one who started it, happy. Is it not? এখন অকমান এডজাষ্ট কৰিব লাগিব এইটো পজিশন গম পাইছে এনেকে বহি আছো অশান্তি হৈছে এইটো হ'ব লাগিব থেংক ইউ We have set aside the judgment of the learned trial court, and we are remanding the matter back to the stage from where the arguments are to be taken up again. We have noticed that the reason for holding the petitioner, the appellant guilty, was only on one sentence, that only because of the sentence given before the learned IO, and not on any evidence based on the trial which was taken during the trial. Then we have also noticed that the alleged offense took place in the year 2017, while the punishment has been imposed upon the amendment which came up in the year 2019. We have also noticed that when the 376 AB had been deleted by the learned trial court, failed to notice that the offense being of 2017 and the petition and the victim having lost the FIR in 2019, the relevant year would be 2017 and not 19. And therefore 376 AB, whether it is to be removed or not, has to be correctly appreciated. Further, when there is any change made to the charge, any alteration charge or addition of charge prior to the judgment, then the parties have to be given a notice that this is what we have done, so that additional evidence can be called in by either of the parties as required. We have also noticed the most glaring part of the error, that there were no issues framed by the learned trial. So therefore, we are remanding the entire matter back. If required, since no one had objected to the framing of the charges or the framing of the issues to be decided. Therefore, from the argument stage, because the defense witnesses have not been discussed at all, prosecution witnesses have not been discussed at all. So therefore, fresh arguments and thereafter a fresh judgment. Till such time, if the appellant applies for bail, the same will be considered on its own merits. Yes. So, thank you.
Right, minor.